Good afternoon and welcome to the Committee for Justice's virtual panel discussion, Mozilla versus Federal Communications Commission, What Next? I'm your host, Ashley Baker, and I'm the Director of Public Policy at the Committee for Justice. I'll now introduce our panelists in the order that they will be speaking. Nathan Leamer is Vice President in Targeted Victory, prior to which he served the past several years as Policy Advisor for FCC Chairman Ajit Pai. In this role, Nathan was instrumental in the Restoring Internet Freedom Order. Additionally, he collaborated on other agency efforts to close the digital divide and promote innovation. Before working at the FCC, he served as a senior fellow at the R Street Institute, where he managed the Institute's government relations and wrote extensively on emerging technology, intellectual property, and privacy. Previously, he served on the legislative staff for Representative Justin Amash, where he also worked on issues related to civil liberties and technology. Randolph May is president of the Free State Foundation. From 1978 to 1981, Mr. May served as assistant general counsel and associate general counsel at the FCC, and he subsequently practiced communications and administrative law. He is a past chair of the ABA section of administrative law and regulatory practice, is a fellow of the National Academy of Public Administration, and has served as a public member of the Administrative Conference of the United States, where he is a senior fellow. Mr. May is the author of a book on communications policy reform, the editor or co-editor of four other books on communications law and policy, and co-author of 2 books on intellectual property. He has also published more than 250 articles and essays on communications, administrative, and constitutional law topics. Mr. May has served as an adjunct professor of law at George Mason University School of Law. He received his BA from Duke University and his JD from Duke Law School, where he serves as a member of the Board of Visitors. Rosalind Layton is a visiting scholar at the American Enterprise Institute, where she focuses on evidence-based policy for information, communications, and digital technology industries. Dr. Layton is also a visiting researcher at Allenberg University's Center for Communication, Media, and Information Technologies, and is a vice president at Strand Consult. Dr. Layton served on the 2016 to 2017 FCC presidential transition team. She has worked on the adoption of technology by emerging countries, produced independent research on the mobile technology industry. Her studies and reports include how Title II harms consumers and innovators, and beyond net neutrality, policies for leadership in the information, computing, and network industries. She earned her PhD in comparing net neutrality rules across 53 countries. She has a PhD in business economics and an MBA from the Rotterdam School of Management and a BA in international service from American University. So the brief presentations by our panelists will be followed by a discussion, after which we will open up the floor for Q&A. I also have the Q&A feature of the Zoom webinar platform open, I believe. This is our first panel here, so hopefully we're not going to run into any technical snafus here, but I figured I would leave open the Q&A function, so you can also send me written Q&As throughout the discussion if you'd like, and I can read those out at the beginning in addition to opening up the floor after we're finished with the discussion. So Nathan, the floor is now yours.
Hi guys, Ashley, thank you again for putting this together. It's great to be on a panel with Randy and Rosalind, two people who I've read quite a bit of their work, especially while I was at the FCC, and have been a really productive part of conversations, regardless of who the chairman is, have been just a huge part of the dialogue that we've had on all sorts of issues relating to internet connectivity, promoting innovation, or protecting consumers. So it's a real pleasure to be here. My apologies ahead of time if for some reason the child runs right through here. It's mine. They're supposed to be there, but it's not in my room. But if that happens for the next hour, that's a strong possibility. So I wanted to kind of walk through a kind of brief history of where things have been going in this net neutrality saga. And it really has been a saga that has been kind of a back and forth, you know, like Fast and Furious 8 or whatever. It's like just nonstop. Every couple of years there's a new thing going on. And so, you know, obviously net neutrality, the conversation on net neutrality goes back to 2003, as coined by Tim Wu in his papers relating to potential hypothetical concerns about the control of internet gatekeepers and access to the internet and treating of information equally and not establishing fast lanes or slow lanes. And this conversation has perpetuated over the course of 15, 18 years now. And has had multiple fits and starts in the policy conversations where people have latched on to questions about where do they go from here. And so there's one level of conversation, which we could talk about later, which is about the kind of politics of net neutrality and how it plays into Capitol Hill or grassroots advocacy groups, or how it's played into even presidential politics at times. But today we want to focus primarily in our initial conversation on the reclassification of internet service from Title I to Title II. So initially, internet service providers were governed under a Title I service, and that was the predominant way we did it up until 2015, where the chairman of the FCC then, Tom Wheeler, changed the way we do it, went with a different direction with the Open Internet Order, which established the internet would be guided under Title II or as a public utility. And it also established this general conduct standard that enabled the FCC new power over the business practices of ISPs, large and small. It was a change to a mother may I approach. And as Chairman Pai likes to say, it was a solution in search of a problem. And that was the way things happened. That went to court, the U.S. Telecom Association versus the FCC, which had a ruling that supported the FCC's Title II ruling back in 2016. That court ruling really hinged around the question of Chevron deference, which I am sure one of my distinguished panelists will discuss further, so that me, who is just a simple former substitute teacher who doesn't know law well, I'll let him handle that. Fast forward then to 2017, when the chairman of the FCC, Ajit Pai, my old boss, kickstarted the Restoring Internet Freedom NPRM as an opportunity to reevaluate the 2015 Title II rules. The FCC's Restoring Internet Freedom Order, which took effect June 11th, 2018, provided a framework for protecting an open internet while paving the way for better, faster, cheaper internet access for consumers, replacing what we saw as the unnecessary or heavy-handed regulatory approach for a common sense rules that will promote investment and broadband deployment. Reminder, FCC Title II is a reference back to 1934, an old-fashioned way of governing things, and we're trying to find, I think what they were looking for with Restoring Our Freedom was a more nuanced, light touch approach that actually dealt with the internet of today and not the large utility of yesterday. Three key points of that we'll go into real quick. One was that it protected consumers, enabling the FTC to police and take action against internet service providers for anti-competitive acts or practices, these hypothetical fears that people were concerned about that have not happened. Question also about transparency, establishing transparency rules that manage the way that ISPs, both large and small, would make sure that their customers had the information they needed to know these are the rules that we're abiding by. If we had changing any of our network management practices, we were going to let you know. And it established that, and it was on the website, the FCC.gov. And the third was removing regulations that hindered broadband investment. And as we saw, over the past year and a half, there's been a huge boon in investment in economic opportunity and broadband deployment that I'm sure Rosalind, who's an actual economist, could go into, not me, a former substitute teacher, could deal with. So that's the latest. But then there's been a recent conversation because a couple of things have happened since 2018. One is states such as California have passed their own net neutrality orders that have led to a bigger question about preemption and a question about what states can do versus what the federal government can do. An issue like the internet, which is inherently interstate commerce, is this a thing that we would have this balkanization of the internet with all these different states passing orders or whatnot? And my colleagues will talk further about that. But then also in 2019, the U.S. Court of Appeals upheld the bulk of the agency's decision to reclassify ISPs under Title I. But the court said that the FCC needs to better explain the impact of those decisions on three key parts. One is public safety, regulation of pole attachments, and its lifeline subsidy program. And so the FCC is currently in the midst of a commenting period that will have the comments are due April 20th. And then 30 days later, I believe, I think it's May 30th, I believe, or 31st, somewhere in there. I'll double check that and send in the comments. There'll be reply comments due then. So that's kind of where we're at right now. And that's kind of the latest from our end. And I think hopefully that can start as a building blocks of kind of the bigger conversation that I think Randy and Rosalind and I will continue to have. So I'll turn it over to my buddies over there.
Okay, I'll go next. And first of all, thank you, Ashley, for arranging this. I think it's timely and we appreciate it. And thanks to my colleagues, Nathan and Rosalind, for participating. I'll just say I could go on and use more of my time, but both of them in different ways, but important ways, have contributed an awful lot to this ongoing debate in a way that I think for my purposes has been, of course, the proper and right and appropriate way. One thing I'll just say at the outset that maybe we can think about throughout the conversation. Nathan mentioned, I think, that the order that was adopted by the current FCC, headed by Chairman Ajit Pai, and we can imagine how much Nathan was really the power behind the throne. But no, he did play an important role. But the point I want to make is the order was styled the Restoring Internet Freedom Order, and I think the freedom part of that really is important as we think about this. I mean, first of all, in a foundational sense, freedom is so essentially tied in with so many aspects of our American character, I think, but specifically in the context that we're going to be discussing today, the freedom that was restored for the internet service providers plays a very important role in terms of innovation, fostering innovation and investment. And I know Rosalind's going to talk about that, and I won't say more about it now, but I just think we ought to think about freedom in relation to those things. I'm going to talk about primarily, or at least next, this ongoing saga in this net neutrality controversy, in which now we've gone back and forth, and why that's the case and what the implications are really going forward. And I mean, one of the papers that I've written was titled the ongoing saga of net neutrality at the FCC and Chevron deference. So I expect most of you are familiar with Chevron, or many of you, the Supreme Court case that we referred to that gave us Chevron deference. And in essence, what that means is that if a statute is ambiguous, then the court must defer to the agency's interpretation of the statute as long as it's reasonable. And in the original Chevron case itself, the Supreme Court characterized that as controlling deference. So it's not some form. There have always been different forms of deference that courts accord to administrative agencies, but this is strong deference if the court finds the statutes ambiguous. So what has occurred in this saga is that back in 2002 really was the seminal decision of the commission when it determined the internet access services. And that's what we're talking about here in a legal sense. Internet access services should be classified as information services rather than telecommunication services under the Communications Act. Okay, well then you want to know what really what is the difference between the two? And we could talk about it in a more complicated way, but for our purposes today, the way to think about it really is that telecommunication services are really like a basic transmission pipeline. In fact, earlier they were called basic services under the original regime before the 1996 Telecom Act. Okay, now information services are basic services that additionally employ some form of computer processing capability. if you look at the definition in the Communications Act, it goes on and talks about processing in a number of different ways and storage and that capability, but it's really, there has to be some element of computer processing. And so you have those two definitions in the Communications Act. Now in 2005, the Supreme Court in the famous Brand X versus FCC case decided, it reviewed the classification that the FCC had made, determining the internet access is in fact an information service. And it affirmed the FCC's determination, and it did it largely on the basis of deferring to the FCC because it found the statute ambiguous, these statutory definitions in the communications ambiguous, and therefore it said, and Justice Thomas wrote this opinion, and it was a 5-4 decision, but Thomas said the definitions are ambiguous, therefore we must defer to the FCC, and affirmed that classification. Now it's interesting to note, and may come back to this later, that a court, the Ninth Circuit Court of Appeals, had reached a contrary conclusion earlier, but Thomas said, nevertheless, if the agency itself subsequently makes a determination, and if it's reasonable, then we're going to defer, despite the fact that a court had already reached a contrary conclusion. Now, we go along like that for a while, and then in 2015, the FCC reversed that classification decision. This was under the Obama era FCC, held that internet access services were telecommunication services, went up to the Court of Appeals, DC Circuit. The DC Circuit says, we're going to defer because of Chevron. The statute is ambiguous. Statute hadn't been changed, of course, by the way. So it affirms the FCC's decision. And then, of course, as Nathan recited, when the administration changed and we have a new FCC issues the Restoring Internet Freedom Order, and the Commission determines that that the Internet Access Service is an information service. That goes back to the DC Circuit again, and the DC Circuit this time affirms the FCC's decision, saying that they're bound by the Supreme Court decision in Brand X. So what we have here, if you're following this saga so far, is really Uber Chevron, right? Chevron on steroids. And, with what I've recited so far, it would be fair to expect that if the next FCC, if there's a change in administration, and we have a Democratic majority FCC, I think we could say without hyperbole, it's highly likely that they would look at this again, same statute, and decide that internet access is a telecommunications service, and seek Chevron deference, right, again in the courts. And we might have that reversal. I think maybe most of you listening to this call probably are too young to remember one of my old favorite songs. Anyone remember Bobby V's song, Like a Rubber Ball Comes Bouncing Back to Me? That was the refrain. I just, every time I talk about this, I think of that rubber ball just bouncing back. But anyway, Nathan, you can Google that song later, and I think you'll like it. So
I'll add it to my Spotify.
Yeah, I let me know what you think. But anyway, with that history in mind, let me say this first. So another aspect, an important aspect of the last DC Circuit decision that we're discussing now, Mozilla, the FCC, had to do with state preemption, because the FCC in its Restoring Internet Freedom Order said that we are going to preempt any state laws, all state laws that are inconsistent with our policy of non-regulation, with non-regulation of internet access. One thing I should make clear, I think this I believe was clear in what Nathan said, but to put it another way, so everyone's on the same page, the difference in these definitions is, of course, consequential, because if it's telecommunications service, that's regulated as if it were a common carrier, a traditional common carrier, which, as Nathan pointed out, is public utility like. But if it's an information service, then under the Commission's view of the Communications Act, it's only subject to Title I, which is essentially, in this case, meant for all practical purposes, aside from the transparency rule, leaving it up to the FTC to enforce transparency, and DOJ and to antitrust and so forth. But on preemption, the FCC issued that blanket preemption order. The DC Circuit and Mozilla said that because Congress had not authorized the FCC to engage in preemption on that broad scale, that the FCC lacked authority to do that, but it left open the possibility that, and it was really a possibility is the way I would characterize it, that if the FCC could show that a state law conflicted, and that's the key term, conflicted with the FCC's non-regulation approach in a way that frustrated it, that the FCC on a case-by-case basis might be able to preempt that state law. There are two state laws that had been adopted. California was one. I believe the other was Vermont, I think. And those two state laws just clearly conflicted with the FCC's approach. And those states agreed not to enforce their laws until the ultimate resolution of Mozilla, and which is to say, at the present time, they're not being enforced, or any other state law, because Mozilla is still subject to potentially cert petitions, and therefore there's no ultimate disposition. So what I want to do before I turn it over to Rosalind, if you keep all of that in mind, that history saga, as we have called it, is sort of think about how we're going to talk about what comes next. One thing that I concluded about 2003, so this was 7 years, I guess, after the 1996 Act, was that these definitions of information services and telecommunication services in the Communications Act, I called them techno-functional constructs back then, because when you look at those definitions, you'll see that they're basically talking about very technical aspects of these services, or and functional aspects. And to me, when I was being candid about it, I was able to say that really, it almost took a Jesuit priest or a metaphysician to take those and parse those in a way that made sense for present purposes. And it led me to believe a long time ago that when we do get around to updating the Communications Act eventually and modernizing it, this whole saga, one thing that I hope will happen, and that I've advocated for a long time, is that we get away from those types of techno-functional constructs and fashion a regulatory regime that looks at marketplace competition as the basis for assessing whether you need regulation and what type of regulation you need. In other words, get away from those types of definitions, and hopefully that day will come. I think it's not, from a public policy point of view, it's obviously most important to have the right public policy in place, and you don't want to end up in this bouncing ball. I don't want to say that we want to end the bouncing ball just for the sake of ending it. If we end up in a place where we would have the public utility regime, that just for the sake of ending the controversy, that's not what we want. But it would be good, I think, because those businesses and providers that provide these services, there is a value in having a stability, some stability of rules in the marketplace. That's not what we have now. And hopefully we'll be able to get to that type of regime at some point, a proper regime. So I'll stop with that, Ashley, and turn it over to Rosalind.
So good afternoon, everyone. I want to say a shout out to all the people who've joined us today. It's so great to see some names I recognize, as well as some new people. And thank you so much to Randy. For those of you who may be new, not familiar with Free State Foundation, I think Free State Foundation, more than any other organization, actually gets the FCC commissioners to their events. They have, better than anyone, you get the chance to interact with the commissioners from both parties. They have amazing events all year long. And it's something I certainly miss right now when we're all tucked away in our homes, because probably one of the best events of the year is Randy's annual event.
Thank you, Rob. Thank you.
Definitely. And anyone who's going to study telecom law, you're not going to get anywhere if you don't read Randy's papers. They certainly helped me. And as I was doing my PhD, I read so many important things. And also all the people who write for Free State Foundation, very thoughtful, extremely valuable scholarship. And I want to say one other thing as I kick off my brief comments here to Nathan, to go back to Chairman Pai's quotation. I suppose you had a hand in it, but he really said that this Title II approach is a solution that won't work to a problem that doesn't exist. And I thought it was quite clever. And I think it's important from an economics perspective, because defining the problem and observing and identifying, quantifying the problem is extremely important. And that is something, again, it doesn't come in necessarily into play in the directly in the legal sense, but if you are a regulatory authority, if you have any notion around what is regulation, in the history of regulation, it is about defining a market problem, identifying a market failure, and remedying it. And the FCC never performed a competition analysis, for one, but also didn't make a finding of market power, of abuse of market power. And that would seem to be quite critical. And if you are going to, so the whole notion around this regime was based upon theoretical harms, potential harms, predictive harms. And if you go back to the writings of the proponents of this Title II approach, they were talking about things like that the ISP was going to harm the network themselves, they would harm the users by degrading or blocking information, and they would harm the content providers. And now we have quite a long bit of time where we've not had these rules. And especially we can look at over 50 countries that have rules, have not had rules, have different kind of regimes. And we cannot find systematic behavior anywhere of ISPs systematically blocking or degrading their networks or harming their users in a deliberate way, in a systematic way. And particularly now in this crisis, where there would be every opportunity for the ISPs to somehow exact this malicious behavior we were told that they would do, that they haven't done that at all. In fact, we see the opposite. We see more than 500 ISPs have voluntarily agreed to not turn off service. They have agreed not to cancel service for unpaid bills and so on. And so that's actually the opposite of what the Title II proponents were going to say. And we have this at a level of millions of people, millions of connections. And so we have the evidence that we need that there is not the systematic harm that necessitates this kind of regime. And I would also say that the ISPs in doing this over the past, it's a 60-day period, they've taken a hit at Wall Street. They'll take a financial hit because of that. They're saying that we're not going to charge the late fees or get customers who don't pay. And they're doing that in spite of what Wall Street would want them to do. So this notion that they are so profit motivated, they don't care about the customers or the content providers, it's belied by the evidence. The evidence shows us really quite a different picture, quite a commitment that the ISPs have to delivering the service, to serving their customers, to making a good experience. So, I kind of just want to say that at the outset. But the other part is, it's also interesting we're here talking about this because we see in this election year, the issue keeps coming back. On April 1st, the Senate Democrats sent a letter to Chairman Pai saying the internet is broken. I thought it was an April Fool's joke, but there's still this view somehow or other that we have, Netflix has record profits and Zoom, this platform we've used, has gone from 20 million users to 200 million overnight, and that there's somehow a problem that the networks are broken. And I think that that's, well, one, the internet's not broken. It's proven itself to be the most resilient, reliable, functional, fabulous platform, right? Because it's being delivered, you have multiple ways to get to it. The ISPs have invested almost $2 trillion to get us there, right? And they're not systematically degrading the experience. But there still remains this narrative somehow that will always assert itself in an election year, that it's broken, that it has to be managed at the centralized level. Now, what do the Title II regulations entail? I mean, as you've heard, there's some very kind of involved sort of things, but essentially what is it? It's a price control, right? It's a price control that says that the price of the internet must be borne 100% by the end user, or the end users overall must bear 100%. And those who deliver the content, the providers, the Netflix, the YouTubes of the world, they pay zero, okay? So that's what essentially the point of this whole regime is meant to do. It's meant to have the users pay 100%, the content providers to pay zero. Now, those of you who live in the modern world know that there's very few networks, zero networks in the world that have that kind of arrangement. In general, we share the cost of things. We will have advertising to support the cost. We have some amount is provided by third parties. The users will share the cost. And the reason that you don't want users to pay 100% is because many users can't afford it. Many users won't adopt it. And that's especially important if we value everyone being connected. And we'd also say is that the way that the content providers send the data to the network is quite disproportionate. So we will have, what's called a power law in the traffic distribution. So you'd have 2 or 3 providers will count for 60% of all the traffic. And in general, you see on the internet what's called a 99-1 rule. 99% of the people visit 1% of the websites that are available on that kind of order. So it's very disproportionate. If we had a more fair, if you will, pricing system, users would possibly pay less, the content providers would pay more, or we might pay the outlays would be shared in a different way, or maybe users paid the same amount, but significant upgrade costs would be recovered by the content providers. So that's the kind of, and I would say though, the part of the success of the Title II advocates is that they have sort of imprinted on the public discourse an expectation of how things are supposed to be. And they have been very successful when there's negotiations going on between ISPs and content providers, that they put a lot of public pressure on the ISPs to give in to the content providers wanting a zero price for their transmission. Again, very anti-consumer, totally pro-industry. So as an economist, I find this whole notion that, users pay 100% and content providers pay 0 is very anti-consumer. So, but in any case, where have we, if we look around the world, we can see a lot of countries have tried different things. We have countries with no regulation at all. We have countries with self-regulation. We have countries with hard regulation. And what's interesting is all of the countries that have adopted very hard approach, for example, Chile was one of the first ones, Netherlands, there's always been a lot of lawsuits, because very typically what will happen is that in order to interpret these things, the FCC or their telecom regulators have to make a lot of judgments. And anytime there's a lot of judgments, it's open to interpretation, it's open to lawsuits. So these sort of things are much better managed by multi-stakeholder model, by co-regulation, by what you would call a consensus building and so on. And in fact, we've seen those kind of models being very successful in the Nordic countries. And again, you don't get a lot of litigation. But what I would say to you is, why do we have so much litigation in the US? Why does this issue continue to go on when we could have resolved it in Congress decades ago? And that's because it's a valuable fundraising tool. There are many groups who make a lot of money off of this topic. You can always, say, oh, save the internet from the Republican FCC, and you can raise money off of that in an election year. So I think that becomes less salient when you have so much more an explosion of new technologies, 5G, for example, where what people, most people who don't have maybe never heard of the issue, they just want to have their network work quickly. They want to feel it's a reasonable price and that they have options. So you're less excited about the government regulating anything. And certainly this notion, we've seen the problems of centralization as we look at the crisis today. I mean, who believes in the World Health Organization anymore? You centralize the governance so high to a global level, it becomes, completely undoable. So this whole notion around the freedom, as Randy was talking about, is very important, because if you are in our American, which is a constitutional democracy, you have the freedom of enterprise, you have the freedom to deploy a network, to manage it the way you want, price it the way you want, engage with the customers to serve their needs, and so on. It isn't the job of the government to tell you what to do. And that is also a First Amendment issue. It's a First Amendment issue if the government tells you how to price your traffic, your service, how do you advertise it, how do you manage it, what technology you use, all of those things. So this is fundamentally such a constitutional issue. I think that's part of why it excites people in so many ways. But from an economics perspective, there is a reason why in the United States we have a tremendous amount of network competition. We have so much competition amongst technologies. I mean, every American today can get a satellite broadband at the FCC's speed definition. And we have now coming online satellites doing 100 megabit per second. So this is fabulous innovation. We have now all of the cable networks are reaching gigabit speeds, okay? We have also wireless networks that themselves exceed that are as fast as fiber, if you will. If you go back to what Tim Wu was writing about in 2003, he was talking about cable at 3 megabits per second, 6 megabits per second. He was rather unhappy. I understand that's not the experience of cable today. It is, it's so fast, the Wall Street Journal was complaining, why is, the cable speeds are so high? I mean, so we're in a totally different world if you look at what the ideological, philosophical underpinnings of the original notion that Tim Wu was writing about in 2000. So the let me just sort of wrap this up, because where I see this, why does this issue keep going? And because maybe net neutrality, if you will, has less salience to the American public as it did, previously, it's now being trotted out in a new sort of old wine in new bottles. It's called digital equity. It's kind of these newfangled terms, but it's essentially the same policies. It's all about centralized control of the internet, preferably a government monopoly of the internet would be a municipal broadband solution. Anything where there's competition between technologies, that is not the goal of the digital equity movement. What they really want is everyone has to have exactly the same connection. Now, that is what we had under the Ma Bell monopoly. Everyone had a rotary phone. and I'm sure as Randy knows very well, that when you're in that, and I remember, growing up, that there was
I do not remember rotary phones. So just to make sure it's very clear, I don't remember them at all.
You had one network, you could only buy your phone in one place, and there was one provider, and that was managed by the government. It was so bad that collusion between the FCC and Ma Bell had to be broken up because there were so many other technologies were coming into play, new devices, and so on. So the end game of Title II is really to make a government monopoly of the internet, which is really the scariest thing that you could think of. It's sort of what China has today. I mean, why would we want that? But that is the goal of Title II is not competition in the sense that you will have competing technologies to give you broadband. You have a cable line to your home, a fiber line, a satellite broadband, a 5G connection, fixed wireless, Wi-Fi, we can go on. All of those, that's not the goal. The goal of Title II is to have one type of network to everyone, which a centralized government agency can control. They control the information, they control the price, they control the technology and what goes across it. And anybody who can kind of understand any basics of innovation at all, that's a monoculture. That's not competition, it's not innovation. And I would just put to you that all of the things that people talked about, oh, this is future-proof, this technology is future-proof, all of that's, everything that's future-proof, we keep inventing new technologies that make what we thought was future-proof obsolete. Today, 5G is making fiber to the home obsolete, right? All of those, whatever we thought was a monopolist of the past, the new technologies, if they're allowed to be there, they make what of the past obsolete. So there's, depending upon the questions, we can get into things, but what I sort of hear from the Title II proponents, especially in the time of this crisis, is that, huge numbers of people don't have broadband. What you have to understand there is you have supply, you have these are not deployment issues. These are issues around demand, in the sense that there's a huge portion of the population, especially elderly, they don't believe that the internet is relevant. So now they may think differently, and that they're probably going to be more likely to adopt. We may see more internet adopters, but we can also see areas where there are people for whom, let's say, $10 a month is too much to pay. I think we've had an amazing experiment in this great evidence with Comcast, for example, over 8 years in their Internet Essentials program. They got 8 million people to adopt the internet for first time. And that is better than any American government program to get people to adopt the internet ever. And that was voluntarily something that Comcast did. They're extending that program through this period. And it's amazing what what corporations can do, if given the chance. And we actually see that exactly at the moment where they should be so bad, turn off, you can only access one thing per day, they do exactly the opposite. They do the opposite. And that is, in fact, what economists, going back to John T. Roll, the Nobel Prize economist who did the two-sided markets theory, what it basically says is when you invest in any kind of network or a platform, you are financially incentivized to get as many people on that platform as possible, as many users, as many content providers. It's not profitably in your interest to block anyone from it. Now, of course, in the process, there'll be competition and old technologies will go away. People are less interested to use DSL today. They want to use wireless, for example. They want to use faster technologies, but the point is still there. If you have major investment, you are financially incentivized to make the most of it through maximizing your users, maximizing your content providers. And then when we talk about competition, this will go over periods of time that where operators will invest in different technologies as they see their ability to capture new customers, to be able to get how can they differentiate, right? It's amazing to see how you have wireline and wireless providers competing for each other all the time. We have a saturated broadband market in the United States. There's essentially no new people to get. So all the ISPs can do is essentially steal the customers from each other. So that's the state of the competition that we're in today. It's quite fierce, I would say, and but that is the nature of it. And You can also, let me just say the last point of this globally, is that if you look at the United States going back to the year 2000, it's accounted for 1/4 of the world's total investment in broadband networks. And that's an staggering number, because the pie itself keeps getting bigger, because China has come, all the other countries are digitizing and so on. The US continues to increase the amount that it invests in the internet. Interestingly, in the European Union, it used to be, going back to year 2003, 2005, it was 1/3 of the world's total. It has shrunk today to about 12%. And that is a staggering failure, in the sense that the policies adopted in the European Union have driven the investment away. It's quite sad. European Union's 2 years behind on 5G. You would never see a European operator saying, oh, I won't cut your service during the crisis. They don't make those kind of promises, because they don't have the cushion in their operating model to do so. So I think that that's the important long-term view that you need to take into account when you look at the effects of policies like Title II.
So why don't we move into, we only have about 15 minutes left here, although we can, run a little bit over time with Q&A if there are a lot of Q&A. I only see one question so far, but for about 5 minutes or so, the discussion portion between you guys, kind of what should be on everyone's radar, what's next, where is this moving through the courts, and also from a policy perspective, what's going on, on the FCC docket.
Ashley, can I just jump in and say one thing here, and I'll talk about what's next, but following up on something that Rosalind came back to a lot to make this point. From a public policy economic perspective, I think all of us would agree that, even without having a PhD, that to the extent there's competition in the marketplace, as opposed to the Ma Bell monopoly situation, then the need for regulation is diminished, and eventually you don't need it if you have competition. And we would like to think that that's the way people would think about this issue. But I want to, people need to understand that ultimately that's not the way that the other side thinks about it. And I'm going to relate an anecdote to make that point. I actually debated Tim Wu back in 2005. I remember it. He's the one that coined the terms, and this was early on. And that was at a time when some of the proponents of net neutrality regulation, like Amazon, was an early proponent. Amazon was, and they would always say that once we have enough competition, or we have competition, then we won't need the type of regulation that we're advocating. And that, you can find that over and over again from some of those proponents. But Tim Wu, and this is 15 years ago now, Tim Wu took the position then that it didn't matter how much competition you had, that net neutrality of the type that he was advocating was a public good in and of itself, because it's always the case that the government should control those pipes. And that was that long ago from Tim Wu. And so it really does come down to a matter of control by the government versus freedom. In terms of where we go from here, realistically, I think probably no one, would take any bet at all that there's going to be legislation this year to resolve, this situation. I doubt if that's going to happen. I know some people hold out hope, but when we get to the point where there is legislation, and I think this is really important, and it's not the way even some of those, ISPs talk about it themselves when they advocate some form of compromise legislation. But from my perspective, it's going to be really important that that net neutrality, let's assume we have a piece of net neutrality legislation. In effect, that's a good part of the whole communications marketplace, right? That's almost like the next Communications Act, if we have net neutrality legislation. And it's going to be really important that there be that the regulation be tied to a marketplace assessment of competition, to go back to the first principles, and not just have categorical not have categorical provisions that, that sound appealing, like there shall be no throttling, or there shall be no paid prioritization, without tying those to marketplace competition. That's where the debate, really hopefully should go. I just want to add one more thing, because Chevron deference has been such a big part of this discussion, and I didn't do it the first time. But as many of you know, I know all the speakers do, and others on the call, there is a real debate in the academic community and among some Supreme Court justices themselves. In fact, 4 of them have indicated that they would be willing to re-examine, to greater or lesser degrees, the whole Chevron doctrine, and so that possibly could happen. Again, I wouldn't bet my house on it, but it's possible. And of course, if that were to occur, then that would fundamentally change the way that we would think about the legal prospects, going forward. And I think that's something, I've advocated that Chevron be re-examined. We ought to, if you're interested in this, and I won't go into it now, but look at Justice Thomas wrote Brand X, right? So, for those of you that are interested, this is really fascinating. He wrote an opinion, dissent denying on a decision. It's called the Baldwin case, denying cert recently, in which he said, I'm the author of Brand X, but I think it was wrongly decided because Chevron deference violates fundamental separation of powers principles, which I think it does. So maybe Ashley will host another forum on that whole thing, but that's important to keep in mind.
Can I jump in also? One of the things I think is going to change is depending on the election, how that plays out. If the chairmanship stays within the same party that it is at the FCC for the next 4 years, I think that would make it more difficult for, by the time we actually get a chance to, someone who once has the political motivation to reevaluate the Restoring Anti-Freedom Act, Freedom Order, I imagine that we'll have a different landscape entirely. I think there's also the question that, as Matthew Prince from Cloudflare said in a recent interview, that the real question about what is an internet gatekeeper has changed over the past 15, 20 years, from the days of the mid 2000s, where you're thinking about a internet provider. Now you're actually thinking about all these other players that are part of the internet ecosystem. And I think that as people wonder the potential harms or hypothetical harms, real or imagined, those are players in industries that are going to get wrapped up into this. And so one of the things that I think we should be concerned about is some people who may be pushing for regulatory arbitrage and an effort to crack down on internet gatekeepers. Well, that definition may change of what that is. And over the course of the next several years, that could lead to major questions on antitrust or major questions on competition and search algorithms and all these other privacy implications that go beyond the scope of what maybe some net neutrality proponents initially wanted. Some of the companies who were pushing for Title II may find themselves on the receiving end of a Title II. And so I think that's the type of thing that is fascinating to watch as we go forward. And so, without legislation from Congress or a higher court, coming down once and for all, one way or the other, I think you're just going to see this constant ping pong back and forth. Now, as a good ping pong player, that's fine, because that's a good metaphor that I can use as I'm playing ping pong with my friends. But the reality is that there is no end in sight at this point, because there isn't quite enough political will to actually have the bipartisan fix on Congress. You have Senator Wicker and Senator Sinema, Democrat, Republican, coming together to try to fix this. But they're not 60 votes, and they're not 218 votes in the House. So that's something that is means I think a lot of people are going to be talking about this for a long time.
Okay, we have 2 questions in the queue. One of them might have partially been answered. I'm going to skip to the second question really fast. It says, with states exercising certain behaviors in relation to net neutrality protections, how are state governments responding? Is there any type of trend, North Carolinian and local elected official?
Well, if I understood the question, I think right now, as Rosalind pointed out, we're not seeing actions by the ISPs that arguably would even fall under, the types of abuses that are intended to be prevented. So, we haven't seen those. Therefore, I don't think there's been much activity recently by the states or since the decision. And practically they're waiting, for the resolution of the Mozilla case. But it is true that with everything in the world going on and all the other things that ought to occupy their consideration, that in the absence of, in the absence of evidence of even what they would consider to be abuses, that is throttling and blocking or so forth, that there's no impetus for the states to do anything. So we haven't seen that. I would say this, that if California, once the litigation is resolved, California has a bill, that is flatly inconsistent with the FCC's policy. It's a stringent net neutrality bill with all the mandates, and I suppose that if California implements its bill, then there's likely to be litigation over that that will focus on the issue of conflict preemption that I've discussed earlier.
One of the things that I would say, and by the way, hope like my background, I waited all day for this one. Of all the things that I would say on top of that is, if you're a local official in your state, and you have concerns or questions about concerns from constituents about net neutrality or concerns about competition, I think the best way of addressing that is to go out into your community and meet with those who are digging the fiber to build out the networks or building the towers, the tower climbers and such. One of the things that we found when we were at the FCC is that there's a really good story to tell of hardworking Americans trying to build out better networks, and companies that are taking responsibility to help those in their communities. And so one of the ways that you can deal with that is having meetings with them, having roundtable conversations with them, and hearing their stories about what they're doing. And what you'll hear most of the time is there are a number of regulations and red tape at the state and federal level that are hindering their ability to deploy 5G small cells, or dealing with cable franchising fees, or things like that really hinder a local community or a state's inability to compete and to bring in better networks to their state. And while you might hear net neutrality zealots and activists say, "Oh, it's all about net neutrality, I'll fix it," it won't. The 2 years that we had net neutrality, open internet order and standards in Title II, it didn't magically all of a sudden appear that networks were built in that small town. And so I think with that mindset, as we see that broadband deployment grows with a light touch regulation, you should be finding ways to tell that story and hear that story from those who are actually deploying it. And so I'd recommend you get in touch with your local wireless WISPA association or US Telecom or other trade associations who can help connect you with those people back in your community, back in North Carolina, or anyone, wherever state you're in.
Okay, we have one other question. This is the one I said might be partially answered. Pretty broad question. Do you think either the Supreme Court or Congress will ultimately determine whether ISPs are regulated as common carriers, or instead will the ball keep bouncing? If the former, what do you think the ultimate resolution will be?
Well, ultimately, can comprise a long time, I suppose, and I don't think it's going to happen anytime soon. I think when there is an ultimate resolution, if it's in the Supreme Court, and let's just assume, this is interesting to think about, that Chevron deference doesn't apply anymore. And so you have a court that's looking at these definitions, and let's assume that's where matters stand. Honestly, I think it's anyone's guess which way the court would come out. As I mentioned, the Ninth Circuit had determined that internet access was was telecom. And you know, I don't want to go into any detail on this at all, but when the Supreme Court looked at it before, it had to do with things like DNS lookup, domain name system lookup, and caching, you know, intermediate storage, whether they were sufficient to add to the processing sufficiently to convert what would otherwise be a transmission service into one that had computer processing. Again, as I said, there's a bit of metaphysics that goes on. I don't think it's clear. I wouldn't want to bet necessarily which way the court would come out, although I know which way I would hope it would come out. But, you know, but if Congress ultimately resolves it, you know, I just always try and be an optimist and hope by the time that comes around, there'll be an understanding there's sufficient competition in the marketplace. Things have changed enough, and there's enough dynamism that it won't want to embody prohibitions that are static and can't be changed as the technology and competition changes.
Okay. I think we have one more question. Yes, let's see. We have one more question in the webinar chat from Katie. There's a proceeding before the FCC dealing with some of the remaining issues on net neutrality. What are panelists' thoughts on this proceeding? Most important parts, let's see, left off after that, is the most important parts of the remanded issues from the DC circuit, and how do you think this will turn out?
Well, I'll say, first of all, one of the parts of that proceeding has to do with public safety and what the net neutrality regime, how that relates to the ability of the FCC to sustain rules that promote public safety. And my own view is that it really, when you think about public safety, the first thing that comes to mind is the need for a priority of public safety communications. You know, you don't want them to take a back seat to whatever that Tiger King that's occupying so much internet bandwidth right now. You probably don't want that. And, you know, that really fits in, you know, that sort of illustrates, I think, nicely, you know, one of the problematic aspects of the net neutrality regime, which would preclude, if it precludes prioritization, then you can see you run into potential trouble. Now, you know, they tend to exempt public safety from the regulations in some definitional sense. And that's maybe good as far as it goes, but the problem is sometimes the organizations and institutions and people that might play public safety related functions don't fit neatly within those types of definitions, right, and rules that the FCC might come up with. So it's an example of why you don't want to have a rigid regime that prohibits, in my view, prioritization.
And one thing to point out for anyone in the audience who are thinking about filing comments for that proceeding, the deadline, correct me if I'm wrong, Nathan, it's April 20th, right?
Mm-hmm. Yeah, so the Restoring Our Freedom remand, the deadline for the initial comments is April 20th. I encourage all of you who are listening who have a voice and want to share it, they should file comments, and specifically on 3 questions. One is how the Restoring Our Freedom affects public safety, as it affects regulations around pole attachments, and as it relates to Lifeline. And those 3 components, again, they're a small subset of the overall conversation on Restoring Our Freedom. So, you know, the order itself has been ruled legal, but these 3 things were remanded for further consideration. I'll just be honest, this is not an issue these are not questions that are mass comments, hey, we like net neutrality or we don't like net neutrality. This is substantive arguments and substantive issues that, you know, is why we should have more events like this to help people think about sort of the nuances in the legal process of this. But again, comments due April 20th, and I believe the reply comments are due May 20th as well, or May 21st. Hopefully, I expect to see comments from all 3 of my friends here. in the docket over the next month or so.
I think that's it for today. I don't see any more questions. We're a little bit over time. Thank you for everyone who joined us. This will be available online as a recording later. I'll post it, and everyone should be receiving a follow-up email probably if you registered. So that will be online. And thank you very much to all of our great panelists. It's a great discussion today. Thanks.
Thanks for having us, guys.
Thanks, Ashley. Thanks, everyone.
Bye, guys.